Malawi Brief.
Pamene kafukufuku wa skando ya Maris Hotel akupitirira, lero Attorney General ali ku Parliament kumene komiti ikuyendetsa kafukufukuyi ikuyendetsa mwambowu. Ndipo Attorney General apereka mbali yawo ya nkhani imeneyi ya Maris Hotel, pamene mamembala nawo amene ali muchipinda menemu afunsa mafunso awo, ndipo Attorney General akuyankha malingana ndi mmene iwo akudziwira za nkhaniyi. Takhalani pomwepo.
View about the fund. It is imperative that it be understood that as I proceed with my presentation, I'm mindful, just as I was when I provided the advice that I did on 28th December 2025, that the fund is established under a trustee deed. It is not a parastatal. And in the trust deed, the Attorney General is not given any mandate whatsoever. There are certain offices that are given mandate in it. So I did carry out my duties as they arose, mindful of what institution I was dealing with. Honorable Chair, like I already said, the Office of the Attorney General is created under Section 98 of the Constitution of the Republic of Malawi as principal legal advisor to the government. And therefore, I am making specific reference to that because it needs to be understood the framework in which the Office of the Attorney General could have taken any positions on this particular issue. Let me start by looking at the nature of legal advice that I gave. Like I said, my office does provide legal opinions whenever necessary to the government, which in this case includes the executive, parliament, as well as the judiciary. And it is important to note that by my constitutional mandate, the Office of the Attorney General does not make commercial decisions, nor does it approve or disapprove business transactions. So advice on matters of policy or administration are ordinarily outside the function and mandate of the Attorney General. Therefore, the decision to invest in a hotel is a commercial and administrative decision belonging to the Board of Trustees of the fund as mandated by the trust deed. And they are bound by fiduciary principles, both under the trust deed as well as under the Pension Act and common law. The trustees are entrusted to assess the viability of the business and whether they should purchase at any particular price. That is entirely for the trustees, because the fund actually gives them absolute discretion to decide on investment. The trustee gives them that absolute discretion. Now, what was the role of the Attorney General in this particular transaction? My office involvement was not proactive. Rather, it was reactive. The involvement was triggered by a formal complaint from the Malawi Law Society dated 19th November 2025. The Malawi Law Society raised serious allegations concerning the governance of the fund board and potential corruption. This complaint warranted immediate attention and I responded on the same by advising the Malo Society that the matter would be investigated. As a result, I did instruct the Anti-Corruption Bureau to issue a restriction notice against proceeding with the sale until the allegations of corruption were investigated. This was a precautionary measure to preserve the status quo and prevent any potential dispersion of assets or finalization of a potentially tainted deal whilst the allegations were being investigated. The action, detailed in my letter to the Malo Society dated 20th December 2025, demonstrates my office's commitment to protecting public funds. Factual findings from the investigations. I need to mention here that the reports that formed my factual findings were twofold. There was one report from the Anti-Corruption Bureau and another one from the Reserve Bank of Malawi. Having issued the restriction notice, the Anti-Corruption Bureau proceeded to investigate the allegations that the Law Society had actually raised in their letter of 19th November 2025. On the other hand, when I called the Board of Trustees to my office to appreciate what they knew or would actually say regarding the allegations that were made, it also became apparent that the Reserve Bank of Malawi, as the regulator of financial institutions, and in this particular regard, the pension fund, was also conducting their own investigations. So my factual findings, as I will comment on them, were informed by the report from the Anti-Corruption Bureau, as well as the report that the Reserve Bank of Malawi sent to me through email on 25th December 2025. Now, on the allegations by the Malo Society, the SCB, having conducted their investigations, they shared me with their report, and out of that report, that's how I then responded to the issues raised by the Law Society. At the same time, some of the issues, there was an overlap with the findings that the Reserve Bank of Malawi did. And though the SCB concentrated on issue of corruption, but in their report, they did acknowledge that there were other prudential issues which had to be looked into, and obviously they were not within the mandate of the investigative powers of the SCB. Similarly, the Reserve Bank of Malawi report found that there were also some prudential issues that had to be attended to. However, since the SCB did not find any evidence or sufficient evidence to sustain charges of corrupt practices or abuse of office against public officers, I toed the same line, because obviously the SCB is the appropriate institution to deal with matters of corruption. However, on the other hand, as I will comment later on, there were prudential issues that they did point to, but clearly demonstrating in their letter that it's not within their mandate. But the same issues were appearing in the Reserve Bank of Malawi report. It is for that reason that in my letter addressed to the Malalo Society, addressing the various allegations that were raised by the Malalo Society, I did end by advising the fund to once again look at the prudential risks that were highlighted both by the SCB as well as the Reserve Bank of Malawi. Now, there's been an issue to do with the resolution, the January 2024 resolution, where it is said that the previous board decided not to proceed with the transaction. Honorable Chair, during my interaction with the fund trustees, the acting principal officer, as well as the chairperson of the fund, indicated to me that there was no such resolution, and they were also not aware if any minutes existed to point towards that resolution. Secondly, the report by the SCB also did not find anything to do with the existence of this resolution. Again, the report by Reserve Bank also did not find anything regarding the existence of this resolution. Based on such facts as presented to me by the board, as well as those two reports, I proceeded to advise in my letter of 20th December 2025 that there was no evidence suggesting that there was a resolution in January 2024 by the board that they should not proceed with the transaction. Honorable Chair, you will agree with me that as a legal advisor, we advise based on facts made available, and therefore, where my inquiry from the trustees, as well as the two reports from those institutions, indicated that there was no such resolution, that's the best I could have advised on. I'm aware that later on, when this inquiry started, some resolution circulating in the social media. I don't know whether it's authentic or not, but to buttress the fact that at the time of issuing of my opinion, there was no evidence suggesting that such a resolution existed. The records showed that multiple independent assessments were conducted in respect to the proposed sale of the hotel. There was a FDH Bank done in 2023, Continental Asset Management sometime in May 2024, and of course EMJ Advisory done in November 2025. All the three reports indicated the business was viable. And in my view, as Attorney General and as a legal advisor, I did not sit in a position where I could form an opinion whether those assessments were wrong or correct. As I said, those are commercial issues. They're not within my mandate, nor is my office structured in such a way that we're able to analyze whether such investments assessments were correct or wrong. And to emphasize that the decision to invest in the hotel, in my view, is purely commercial. The law just comes in to aid the process to ensure that there's compliance with all legal and regulatory requirements, and therefore there was no basis for the Office of the Attorney General to advise on the price of the hotel as to whether it was too much or not. It was not within my capacity and indeed my mandate. And perhaps to emphasize that even where the Office of the Attorney General vets various contracts that government institutions enter into after the PPDA has approved, my office does not vet prices. It's not within our mandate. We look at the law and whether the law has been complied with. Prices are not within our mandate. In that vein, I therefore did not form an opinion as to whether the price was too much or not, because it's not within our mandate. Now, Honorable Chair and Honorable Members, there's been a misrepresentation in the media on what my office did as regards this particular transaction. It has been falsely claimed that the Attorney General authorized or endorsed the purchase. I categorically state that that is incorrect. And for that reason, Honorable Chair and Honorable Members, I will take you to the text that seemed to be misunderstood or misrepresented in my letter of 20th December 2025. And I will read the relevant part. In view of the magnitude of the transaction in this matter, and indeed out of abundance of caution, and in order to ensure that members' savings are protected within the prudent investment principles and regulatory requirements, the board is advised once again review the attendant receipts and satisfy itself of the available mechanisms for the management / mitigation thereof. Once that is done, the board is advised to proceed with and conclude the transaction in the best interest of the fund and its members. To mention that this statement has two components, which I would want to highlight. Honorable Chair and Honorable Members, the first part is that there is a conditional directive which is being given to the fund. And this was not a green light, it was a conditional statement. I explicitly instructed the board to once again review the attendant receipts and ensure compliance with prudent investment principles and regulatory requirements. This was a mandatory condition precedent to any further action. I did not assess those receipts because they fall outside my mandate. Other than that, those ordinarily would be assessed by the Registrar of Financial Institutions, in this case, the Governor of the Reserve Bank of Malawi and his team. On the other hand, the trustees have an explicit mandate to do the assessment by themselves because they carry with them fiduciary obligations in terms of how they run the fund. So even though the trust deed gives them absolute discretion to decide on what sort of investment they should do, but that comes with the fiduciary obligations to make sure that the investments they decide to engage in must be those that are within prudent investment principles and also do adhere to regulatory requirements. So what I was doing there is to remind them that you have this duty and make sure you do what you are supposed to do. So I advised them to do that risk assessment. And I did that mindful that the RBM report had raised issues regarding those risks, and therefore that informed my position in saying you need to address the attendant risks. And by the way, the report that was given to me was by the Reserve Bank governor was also made available to the fund trustees, and therefore they understood squarely what I meant when I said they must review all those risks. And to also buttress the fact that the language was so clear, and I was fortified in my believing so, because the trustees are people that would properly understand their roles, and I believe they did understand their duties and roles. And for that matter, they are led by a chairperson who is a lawyer, trained draftsman, and therefore the reading of any legal language would not be an issue. So my belief was they will attend to those risks as advised, and also as advised by the Reserve Bank of Malawi. Now, the other bit of that statement would be deemed as permissive, as a permissive statement. The phrase proceed with and conclude the transaction is entirely dependent on the satisfaction of the first condition, which is look at all the risks, satisfy yourself that you have complied with them, then you can proceed. I was mindful of their absolute discretion as granted to them by the trust fund, the trust deed. Therefore, it was not in my space to begin to take away their powers. But still, my emphasis was in going ahead with your decision. You need to make sure that you've attended those risks, and also that the conclusion of the transaction should be in the best interests of the fund and its members. That was coming from a basic understanding of the law of trust, where a trustee knows that he must put the interest of beneficiaries first. That's why I emphasize on the best interest of the fund and its members, dependent entirely on satisfying the condition precedent, which is to deal with the prudential issues that the Reserve Bank of Malawi had raised, and which I therefore did raise with the fund. It was not an authorization of the transaction's merits, but it was a legal statement that if the board fulfilled its fiduciary duties and prudential reviews, they could proceed from a purely legal standpoint. Given that the SCB had created the transaction of corruption at that stage, so my advice was process-oriented, not commercial. Now, in terms of alignment with regulatory advice, my advice was further reinforced by the Registrar of Financial Institutions in his letter, which he wrote to me on 6th January 2026. But of course, I received it on the 10th of January 2026. Dr. McDonald Mwale stated unequivocally that the transaction should not proceed until the identified prudential risks were addressed. In my view, that was in line with what I had already told the fund. Address the prudential issues first, and then only then can you proceed with the transaction. So you can actually see, Honorable Chair and Honorable Members, that my advice and that of the Registrar of Financial Institutions was at par to the fund. Now, allow me, Chair and Honorable Members, to also talk about the question of authorization and legal authority. I wish to draw the committee's attention to a fundamental principle of administrative law, that an officer created by a particular law should only act within the mandate of their law that creates that office. It is in that regard that the Attorney General has no power to authorize commercial investments by any statutory body. To suggest that is to misunderstand the separation of powers and responsibilities within the government setup. The power to invest lies with the Board of Trustees as given to them under the Trust Deed and the Pensions Act. My office does not and cannot sit as a super board over state organizations. Importantly, it is important to note that the trust fund is essentially a body corporate. Now, the danger of conflicting legal advice with commercial endorsement. If the Attorney General was to authorize transactions, it would create a dangerous precedent. It would absorb the powers, the fiduciary duties that are placed on boards and the people that are entrusted to hold positions in those boards, and perhaps even transfer the liability that arises from any decisions made in investments to the Office of the Attorney General, yet the Office of the Attorney General is neither structured nor mandated to do that. The role of the Attorney General is to advise on what the law is and not to show how businesses should be run. In that regard, the final decision on this particular investment would only lie with the trustees of the fund. And that's why you may have seen, Honorable Chair and Honorable Members, that the agreement for the sale of this hotel was signed by the chairperson as well as another trustee, because those are the people that are mandated to transact, and they were doing so within that mandate. And allow me, Chair, Honorable Chair and Honorable Members, to comment on the regulatory concerns, like I earlier on said, that the Reserve Bank had raised. In my letter of 28th December 2025, I did acknowledge the serious prudential concerns raised by the Registrar of Financial Institutions. As I have already said, the RBM report that was made available to me did highlight potential liquidity mismatches and concentration risks, among other risks. And to emphasize, Honorable Chair and the members, that those are not legal opinions. Those were risks identified by a team of experts within the Reserve Bank of Malawi, who are essentially economists, finance people, and the like. So they were not legal in nature. And because they are coming from financial expert analysis of the risks, that is why I did emphasize to the fund to review those issues before proceeding to finalize the transaction. Honorable Chair and honorable members, the subsequent order by the Reserve Bank Governor to reverse the transaction underscores that the prudential risks could not have been adequately addressed by the board. And that confirms my conditional advice to review the risks before proceeding with the transaction. Honorable Chair, I need to report that a few weeks ago, I did receive a dossier of documents from the fund in which the trustees were explaining how they have dealt or intend to deal with the prudential issues or risks that were highlighted by the Reserve Bank, and which I did ask them to look into before concluding the transaction. Honorable Chair and honorable members, my hope and trust is that the Governor of the Reserve Bank, being the person mandated under the law to look into such issues, will assess what the fund has submitted and see if the fund is within the regulatory framework, and perhaps whether they've attended to the issues as raised by the Reserve Bank. Again, to emphasize here that as the Office of the Attorney General, we're not able to comment on the responses that were given by the fund on the prudential issues, because that's not within our mandate. That's the mandate of the Reserve Bank Governor. In conclusion, Honorable Chairperson and honorable members, the Office of the Attorney General acted with diligence, transparency, and within its legal mandate. Upon receiving the complaint from the Malalo Society, we initiated an anti-corruption probe. And upon receiving the reports from SCB, as well as the Reserve Bank of Malawi, we issued a cautious, conditional legal guidance, explicitly directing the board to first address the serious prudential risks. We did not authorize the transaction. We merely facilitated a lawful process which the board was then obliged to execute responsibly within their fiduciary duties. My office remains committed to the rule of law and to providing sound legal advice to government institutions. I thank you all for your attention. Thank you, sir.
Thank you, Chair, for giving Zomba Sondole a chance to ask the Attorney General. I have two questions. The first question is that I wanted the Attorney General to tell this committee when did he appointed as an Attorney General, and when did he start the work as an Attorney General of Malawi? The second question is, can he tell this committee when did he know about the purchase of the Amaris Hotel? Thank you, Chair.
Thank you so much, Zomba Sondole. Attorney General, you can take those two from Zomba Sondole. Over to you.
Thank you, Honorable Chair and Honorable Member from Zomba Sondole. I was appointed as Attorney General on 27th October 2025. And it was with immediate effect, so I immediately started discharging my duties. I only got to know about this particular transaction on 19th November 2025 when I received the letter from the Malalo Society. Thank you.
Thank you so much. Nkarabe Central.
Thank you, Chair. Attorney General, good morning, sir. I have two questions. The first one is the pensions fund bought Sigerege Hotel before this transaction. They used the pension funds to buy Sigerege Hotel. Was the office involved, sir? That's the first question. The second question is several officers of the fund has appeared before this committee and other board members. We have a report that in March 2024, there was a meeting in Mzuzu called and chaired by the former Chief Secretary, Madam Colini Zamba. In that meeting, Madam Zamba issued a number of directives. Among them, one of them was that the sale transaction should be concluded with speed and be concluded within 30 days. There were reports emanating from that meeting. There are several other directives. Are you aware of that meeting, sir? And did you access that meeting? At those minutes, did you access? Thank you very much. Because they will very much help you. Did you access those minutes of the meeting called by OPC then in Mzuzu in March 6 March 2024, chaired by Madam Colini Zamba, instructing the fund to move with speed and conclude within 30 days? Did you access those minutes, sir? Thank you very much.
Thank you so much, Nkatabe Central, our senior. Attorney General, you can take those questions from Nkatabe Central. Over to you.
Thank you, Honorable Chair and Honorable Member from Nkatabe Central. I do not have information on how Sigerege was purchased by the fund. And in my dealings...
General, can you switch off your mic? I just want to bring...
Menemo ndi mmene zinayambira, koma chifukwa cha phokoso limene likuchokera kumene ma MP anyuwani akulumbirisidwa, acheya ayimisakaye msonkhanowu kuti upitirire pokhapokha phokoso litachepa. Ndiye khalani pomwepo poti ife tikhala tikupasirani chilichonse mmene chikukhalira.